What's up, YouTube, or anywhere that you see this video? Today's discussion is going to be on the attorney-client relationship. I had someone contact me asking about where it is in the corpus juris secundum and if it's actually there. So I'm going to show that to you today. I have to say that I do not give legal advice. I am not an attorney, and this is not an intent to practice law. So here we are. We're just going to read from section 4, since this is the pretty much the portion that I was requested to read. All right, so this is what section 4 says. First duty, not to clients. Counsel must remember that they too are officers of the court, administrators of justice, oath-bound servants of society. Yet their first duty is not to their clients, as many suppose, but is to the administration of justice. That to this their client success is wholly subordinate, that their conduct ought to and must be scrupulously observant of law and ethics. And to the extent that they fail therein, they injure themselves, wrong their brothers at the bar, bring reproach upon an honorable profession, betray the courts, and defeat justice. This can be found in U.S. v. Frank, guys. It's a New Jersey case. I already looked it up. The case, I'll have to look further into the case to find out why this was in it, but it's definitely part of the case. And these points of it being reversed, they're relevant to the topic of what most of us talk about. Because of the case, it was where an attorney, he ended up backing out of working with two people that he was an attorney for. So yeah, that's the only grounds that it was reversed on. Let's go down to the second point, the conflict of duties. In case of conflict between attorney's duty to client and that to the court, his duty to court must prevail. So it's saying, hey, if there's a conflict of interest, then get out of it. But you have to, with all that has to be a formal thing, and you have to ask for permission from the judge. Again, this is not legal advice. This is just from my own research and my own investigations. I'm going to ask you guys to do your own research as well, so that you can get a proper understanding. Where duties to court and professions conflict with those an attorney deems due to a client, from friendship, he should abandon the relationship of the attorney. So if they're in too deep and they've created a relationship with you and they feel like they have to defend you no matter what, they should probably either step away from their relationship as being that person's attorney. Last piece, oath shows first duty is to the public. Oath of an attorney to support Constitution and obey laws show intent to charge him with a public function, which is superior to private interest of clients. So all in all, the first person that they work for is not the client. So this is why many people go to the extent of saying, oh no, I'm not going to get an attorney. Attorneys are corrupt. I mean, not to mention the things that I have witnessed that are corrupt that they've done or that other people have experienced. So yes, guys, as you can see, the corpus juris secundum, this is on page 707. The corpus juris secundum, the seventh one, under attorney-client, the fourth section or subsection. Do you want to, guys, go and do your own research as far as section 3? It explains that what are deemed practices of law and what are not, but also you have to look at up-to-date things for your own city and state. Don't just take my advice. Go do your own investigation. And as you can see here, investigation of a case does not necessitate the practice of law. Investigation being synonyms with detection, since it is not part of a lawyer's function to ferret out evidence which may be helpful to his client in prosecution of such client's claim. So you can do investigations and be able to come up with information. But there's other things as well within here, guys. If you want to go over it, or if you want to have an open discussion as we read it, feel free to contact me. But from this point, I am out.